topic of this debate is whether or not states should surrender sovereignty and comply with humanitarian international law. On the issue, I take the affirmative stance that states should surrender their sovereignty and comply to humanitarian international law. The first piece to understanding the debate is understanding what humanitarian international law is. International humanitarian law is a set of rules which seek, for humanitarian reasons, to limit the effects of armed conflict. It protects persons who are not or no longer fighting or participating in the hostilities and restricts the means and methods of warfare. International humanitarian law is also known as the law of war or the law of armed conflict. International humanitarian law covers two main areas: the protection of those who are not or no longer taking part in fighting, and the restrictions on the means of warfare, in particular weapons, and the methods of warfare, such as military tactics. International humanitarian law protects those who do not take part in the fighting, such as civilians and medical and religious military personnel. It also protects those who have ceased to take part, such as wounded, shipwrecked, and sick combatants and prisoners of war. While there have been countless violations over the years, there's a clear moral responsibility to surrender a level of sovereignty to comply with humanitarian international law. One of the largest misconceptions about humanitarian international law is that you must completely surrender sovereignty in order to attain the benefits. But instead, there's not a complete abolition of sovereignty, but a temporary suspension. And it protects the individuals that I mentioned earlier by allowing for them to have legal protections in the states which they reside, and ensures that prisoners of war as well as civilians are being treated fairly even during the conflicts that were mentioned above. Compliance to these codes can save civilian lives, as civilians are more often becoming victims of war and have a right to protection. Civilians are not usually the ones who start war and are typically just bystanders that happen to become victims of the crimes and of the violence that happens in these wars. As such, choosing to flee the country or to seek protection should not be something that is violated. In addition, hospitals have often been targeted in violation of humanitarian international law, which has resulted in the deaths of many wounded soldiers as well as the deaths of many civilians. International humanitarian law is pursuant to the Geneva Convention, which in legal terms means that those who have signed the Geneva Convention have a legal obligation to adhere to humanitarian law. While it's in writing, it's also recognized in international law that those who have signed the Geneva Convention are pursuant to sections 1, 2, and 3 of the convention that require them to uphold and adhere to any requirements based in humanitarian law. In a more optimistic light, adherence has the ability to save and protect countless lives while also ensuring the ability to look for a peace process and to have a successful peace process in the international sphere. Without the ability to de-arm and limit militarization, we lack the ability to ultimately attain peace. Thus, international humanitarian law is not a complete loss of sovereignty, but instead a contract that ensures the lives of thousands are saved and protected. Without these types of processes, we would lose a significant portion of the international peace process and rehabilitation following armed conflict. Thus, in order to preserve the peace process and allow for us to protect the lives of those who are innocent in any armed conflict, it is important that we uphold humanitarian international law and hold nations who have signed the Geneva Convention, as well as other nations who benefit from international law, accountable in the sphere.